Greg Woods teaches criminology, criminal justice, and legal studies courses at San Jose State University and other college campuses throughout Northern California. Calculated to address significant issues impacting our nation, Professor Woods wrote the first of its kind training model, Policing in the Current Political and Social Climate, which he regularly presents to members of the San Jose Police Department and other agency personnel. He regularly participates with the Los Angeles County Sheriff Civilian Oversight Commission to build a bridge between the Los Angeles County Sheriff's Department and the communities it serves. Woods conducted training seminars through a foreign language interpreter to top Beijing police officials from the Ministry of Security of the People's Republic of China, emphasizing sources of legal authority, limitations to the use of force, and legal remedies in response to police misconduct. As an internationally respected legal trend and law enforcement expert, Professor Wood's analysis and commentary are regularly featured on television and radio, podcasts, and in print. He received his Doctor of Jurisprudence from San Francisco Law School and lives and works in the Bay Area.
I'd like to begin by emphasizing stereotypical perceptions of the worst behavior exhibited by members of the legal profession through the recitation of a lawyer joke, but I won't. The problem with lawyer jokes is that lawyers don't think they're funny, and nobody else knows their jokes. Lighten up. The Pew Research Center conducted a survey recently of the United States, and they found that adults found something revelatory in the 58% of Americans that said that they believe that life was better 50 years ago. And in the time that we have lived since that particular period in our history, there has been considerable changes, a trajectory through time spiraling downward to the lowest common denominator, a crisis of trust in those very institutions of justice, law, how we dispense justice, what expectations we have for those within the legal profession. Back then, wars on poverty, crime, Vietnam, Watergate, the resignation of our president, a Duke University educated lawyer, I might add, pardoned by his successor. Let's not forget Associate Justice Abe Fortas, way back in 1969, resigned from the Supreme Court after being nominated by the president to be the Chief Justice. Politics at play. Interestingly, it was the president who would subsequently resign under the cloud of impeachment, who didn't want Abe Fortas as the Chief Justice of the Supreme Court. For whatever reason, the court of public opinion was deployed. And it was prior to Fortas, as he resigned from the Supreme Court, denying he had done anything wrong, who ultimately returned to private practice and did that throughout the rest of his life. He resigned from the Supreme Court to avoid the appearance of impropriety. The impropriety, as the Life magazine article identified, was his relationship with a Wall Street financier, Lewis Wolfson. Wolfson. We think of a wolf as a salivating, fanged individual who might very well be hiding behind every corner. He was a Wall Street financier, and he was a personal friend of Abe Fortas. He provided Abe Fortas money in exchange for legal advice, money that Abe Fortas returned for fear that there would be an appearance of impropriety. Nevertheless, upon his nomination to be the next Chief Justice of the Supreme Court, it were the political and also those aspects of the media that were rallied to polarize public opinion, so that ultimately he resigned, falling upon his sword. We look around, particularly today, with the Supreme Court of the United States, the federal judicial system, and the way that we dispense justice from coast to coast, and we can conclude that there truly is no shortage of conflicts nor challenges in our time. As the Pew Research Center would conclude, we have a crisis of trust. In what follows is an informed analysis of questionable decision-making under difficult circumstances, requiring practitioners to employ the highest standards of care to preserve the rights and remedies of those they serve and promote the credibility of the justice system. Allegorical and aspirational at times, if not compelling, more than a feeble attempt at humor, in our time together is an exploration of the true nature of things. Some say the formula for comedy is tragedy plus time, and in what follows is tragic at times. Time and again, in spite of efforts to operate pursuant to the letter of the law, things go wrong. However, the time it takes us to appreciate the court of public opinion in response to questionable behavior demonstrated by members of the legal profession, both in and outside courtrooms and back rooms of an ethically challenged justice system, is well worth the effort. For the practitioner who has presumably seen and heard it all before, this is an innovative approach to ethics, to see things differently, for zealous representation, to pursue the interests of justice in a post-pandemic, ever algorithmic world, with increased numbers of those conditioned through isolation, wireless, yet plugged into a trend where artificial intelligence streamlines lives, as well as the legal profession, supplementing research, communication, and advocacy in ways we may only appreciate in retrospect. Ways to authenticate, equivocate, validate, and vindicate the legal profession. If we consider the appearance of impropriety, we need look no further than the Code of Conduct for United States Judges, Commentary, Canon 2A. An appearance of impropriety occurs when minds that are reasonable, with knowledge of the relevant circumstances, disclosed by a reasonable inquiry, would conclude that the judge's honesty, integrity, impartiality, temperament, or fitness to serve as a judge is impaired. Public confidence in the judiciary is eroded by irresponsible or improper conduct by judges, including harassment and other inappropriate workplace behavior. A judge must avoid all impropriety and appearance of impropriety. This prohibition applies to both professional and personal conduct. A judge must expect to be the subject of constant public scrutiny and accept freely and willingly restrictions that might be reviewed as burdensome by the ordinary citizen. These are ways to authenticate, equivocate, validate, and vindicate the legal profession. The ethical questions are always in the way technology is used and what we do with the tools at our disposal. Platforms from which to receive and disseminate information, from remote locations for convenience, at arm's distance for efficiency, security, judicial economy. We're phoning it in for all the right reasons. We begin with illustrations of extrajudicial influences on the judicial process, all impacted by the court of public opinion. Cautionary tales illustrating significant challenges of our time, and a call to action in response to the palpable deterioration of trust between an ever polarized population and an imperfect, if not detached, justice system. In what follows are timeless truths for the way forward. Ultimately, it's up to those within the sound of this recordation to become familiar with the codes of professional responsibility that govern the jurisdictions where they operate. It's worth repeating that the righteous path preserves a righteous conclusion, and the way to be successful is by maintaining a moral compass, to navigate obstacles, dispense justice, and in so doing, contribute to a more perfect union. Increasing understanding improves the access to justice through commitments to one's oath of office, independence of mind and decision-making, and accountability by taking responsibility and offering transparency whenever appropriate. Oath, independence, and accountability. For practitioners, the way is ultimately a personal approach to the profession to serve those who seek their expertise within their official capacity. Time and again, judicial declarations are suspect. Adjudications with perfect procedure, perceived not unlike the thumbs down hand gesture at an ancient Roman Colosseum, where the fate of a fallen gladiator depended upon the favor of wealth, access to power, and an ever intoxicated audience. Without ethics, what's the worst that can happen? Apathy, insurrection, anarchy, irreversible erosion of the public trust, goodbye, goodwill, forever. Unlike the Circus Maximus from Caesar's Rome, our legal tradition is bound by the Constitution of the United States and laws governing the many jurisdictions throughout our great nation, legislative solutions for nearly any conceivable problem. New statutes fashioned every year to be applied to parties with adverse interests, the process ever incorporating extrajudicial sources of data, personal information made available with state-of-the-art technology, algorithms, artificial intelligence, increasing our awareness from social media platforms, reinforcing stereotypical notions of the profession, biased interpretations of victim and aggressor going viral, catching the attention of an otherwise uninformed population, confirming suspicions, adversely impacting the public trust, and the way justice is dispensed. We begin with high-profile examples of tragedy, illustrating the court of public opinion, followed by key concepts from the ethical tradition and select sections from the ABA Model Rules of Judicial and Professional Conduct. I'd like to begin by helping us better appreciate how the court of public opinion brought about justice following an adjudication, not through the appellate process. This is the brainchild of Professor Michelle Dauber, Stanford Law School, Professor Michelle Dauber. She had a friend of the family, her name, Chanel Miller. Chanel Miller, who ultimately in 2019 published a memoir, Know My Name, because prior to 2019, it was Chanel Miller who was known as the victim. And the way we better appreciate the rights and remedies available to a victim and how the victim's rights might very well be lost while we are entertained with perhaps the most dramatic evidence of the worst of human behavior, predatory, not unlike somebody with the namesake of Wolf, was Brock Turner, the Stanford educated, well, at least he was pursuing his education. He was deprived of that opportunity, truly with the decisions that he made, clouded one night, perhaps by adolescence, a predatory impulse. We can only speculate what was going on through the mind of Brock Turner that night when an intoxicated Chanel left the fraternity party where she was resting so she could sober up, so that she could go home. She was preyed upon by Brock Turner. The Brock Turner case, the notorious Brock Turner case, where the pictures subsequent to the adjudication where he was found guilty of 3 of 5 felony sexual assault counts. His face, his mugshot, the blue-eyed devil, perceived in so many ways to be the recipient of a lenient sentence, the lenient sentence from the seasoned judge, Santa Clara County Judge Aaron Persky, who held court. The very respected Santa Clara County judge, who was elevated to that position simply because of the respect that he had garnered from the legal community, found himself reviewing the matter. He listened to the evidence. We understood, at least upon the declaration, that judicial declaration where 3 of 5 counts, where he was found guilty, where following that particular adjudication, it was Brock Turner who was sentenced to time in the county jail. 6 months for which he served 3. He was released on good behavior. Though he had to register and still must register for the rest of his life as a sexual predator, it is the court of public opinion that perceived his sentence to be merely a slap on the wrist. It was Judge Aaron Persky who applied the letter of the law in this particular case, this case that polarized an entire community, the community of Northern California, who, upon the news of the gavel falling, with the help of Stanford law professor Michelle Dauber, published the victim impact statement from then the anonymous victim. Way back in 2016, it was the victim impact statement that was made available through media channels that helped the world better appreciate the significance of sexual assault, particularly on the West Coast, where the California legislature was impacted by the publication of the victim impact statement, something that was made privy to the jury, the trier of fact, as we concluded what it was that Brock Turner did. Whether or not Brock Turner, in his violation of the California Penal Code, being found guilty for felony sexual assault, receiving a sentence not unlike, well, so many examples of apathy. Perhaps it had something to do with the background of Brock Turner. Brock Turner had received a full ride scholarship to Stanford University so that he might swim on their behalf. He was on the road to the Olympics. He was well respected on the campus, at least until this moment that he decided in 2015 to become the predator for which he will always be remembered. Those piercing blue eyes. They stare at you from the television screen, from the internet portal, and they remind you that perhaps there is dissimilar treatment when it comes to the way that justice is dispensed, particularly in California. Perhaps there are those who receive lenient sentences, those who have the benefit of an education, those who might very well be perceived to be from a trajectory of complexion that might very well garner the slap on the wrist, as opposed to those high profile examples of much more severe sentences, arguably being dealt by those courts across the country for similar behavior. At such a point, it was made known to the general population that a rapper, a, well, rather notorious rapper by the name of Meek Mill, a black man who was serving time in prison for a very similar case. He wanted to insert himself into the public eye, and he did so by making known that his sentence was dissimilar from the sentence that has been perceived as lenient. It was Michelle Dauber who led the case, well, the case for recall, because following this adjudication within the letter of the law, pursuant to the discretion of Judge Aaron Persky, who looked at the background of Brock Turner and concluded that he was never in trouble before, that he was educating himself at Stanford University, and there was a great likelihood that he would not reoffend, and therefore, by concluding through the pre-trial sentencing report and other sources that testified to his character that this was a one-off, This was a troubled young man who made a mistake and therefore deserved the leniency and mercy of the court. Well, that was until the court of public opinion was able to review the publication at the discretion of Professor Michelle Dauber from Stanford Law School, who had a relationship with the family that Chanel Miller comes from. And because of this relationship, she was privy to the inside track, the impact on the victim, something that we typically forget about when it comes to the dispensation of justice and how it is that we assemble evidence to bring about a guilty verdict. And as we consider the interests of the victim here, where we have the great state of California and the people of California versus one Brock Turner, the defendant, not within this equation, not within this adverse interest being represented within the court, do we truly appreciate the impact on the victim. This changed. And it changed because of Professor Michelle Dauber from Stanford Law School, who understands the power of the court of public opinion, making available in every airport by virtue of printing, online acquisition, the victim impact statement. It's the victim impact statement that is usually reviewed prior to the decision of the judge to impose a sentence. Nevertheless, this particular victim impact statement, which was made available to the general population upon the adjudication, gave greater scrutiny, not only to the court of Santa Clara County, the superior court from where Judge Aaron Persky ruled, but on Judge Aaron Persky personally. After Judge Aaron Persky, 2 years later in 2018, campaigning for his own interests, antithetical to the interests of Dauber and the Miller family, Chanel Miller, who at that point still remained anonymous, it was her interests that were then being adjudicated in the court of public opinion, leading to the recall by way of a petition campaign that was the brainchild of Dauber, ultimately was successful, giving Judge Aaron Persky the distinction of being the first California judge to be recalled in 86 years. We can consider the world 50 years ago, perhaps 80 years ago. Consider the changes that have been employed since then. Consider the trajectory where we might scrutinize the adjudication of a court of law within the superior court outside of the appellate process, where we might add that it was Brock Turner, upon being released, being subject to the compulsory sexual predator registration requirement, a sex offender for the rest of his life, to complete rehabilitation programs for sex offenders. Turner, after serving 3 of the 6 months, he appealed. His appeal was denied. Widespread criticism, not only of Persky, but of the way that we adjudicate justice within the state of California, specifically as it relates to sexual assault victims, the victims of the system, the power of the court of public opinion. It's Professor Michelle Dauber from Stanford Law School that we can learn from as we attempt to apply these types of principles within our own approach to the practice. Persky was recalled by county voters on June 5th, 2018, with 61% of the voting agreeing to recall him. It was Aaron Persky who, following his dismissal from the court, lost his job after giving such a lenient sentence. He lost his job not only as a judge, but in 2019, he lost his job as a junior varsity girls tennis coach at a local high school. It was the parents of the high school who concluded that they believed that their daughters were not safe within the close proximity of this individual who allowed the blue-eyed devil the predator, Brock Turner, to go free. But this isn't the only example from recent time where we can look at the power of the court of public opinion and how it is that public opinion might very well help us to better appreciate how it is that we conduct ourselves, how it is that we expect judges and those other individuals within the legal profession to conduct themselves. It's the worst in human behavior that we might be able to illustrate as we further examine the tragedy that is associated with the impact of the court of public perception, because it was United States District Court Judge Esther Salas from the District of New Jersey who was in the basement in July of 2020 when the doorbell rang. And at the other end of the door was presumably a Federal Express delivery man. Now, this was July 2020, and those of us who understand the recent history, we can conclude that this was the pandemic era. And perhaps this is why the son of Judge Salas, Daniel, 20 years old, still at the home while Judge Salas was in the basement. It was the son Daniel who saw the uniformed UPS driver at the door ringing the bell with the face covering. He didn't recognize the UPS or delivery driver, the Federal Express uniform that he acquired. This was a delivery man, although it was 5 p.m. on a Sunday afternoon. No one expected what was about to transpire, particularly Judge Salas, who heard the gunshots, because after the son opened the door, he was immediately shot to death. He was shot to death by someone who we would subsequently learn was a litigant, an attorney who was before Judge Salas 5 years earlier. The FBI engaged in an investigation. They ultimately concluded from the evidence that they found that the individual who was responsible for this heinous act was Den Hollander, Roy Den Hollander. He was a George Washington University educated lawyer. He identified himself as a men's rights activist, and he had recently found out, according to the investigation, that he was terminally ill with melanoma, a type of cancer that is uncurable. And so he put together a list. In fact, it was the FBI that found an online manifesto consisting of a number of desired targets. One such target was in California, where it was from the shooting death of the individual in California, where Roy Den Hollander got on a train. He went across the country. He found himself in the neighborhood of Judge Salas in New Brunswick, New Jersey. 5 p.m. on a Sunday afternoon, he rang the doorbell. He was ready for action. He produced his firearm, the same firearm he used in a California killing, literally drawing a line through the individual's name who appeared on the list from the manifesto. And he immediately left the scene of the crime, but not before shooting and gravely injuring the husband, Mark. Daniel, the son, was killed. Mark was gravely wounded. Judge Salas, in her excitement, attempted to uncover what was going on, where we can conclude by reviewing the online manifesto that it was Judge Salas's name that was the intended target of this particular heinous act. Following this act, where we conclude that this particular attorney, Hollander, the men's rights activist, an individual who gained a reputation for engaging in frivolous lawsuits, who had a case before Salas, and before he committed suicide by gunshot, before this information was uncovered by the FBI, he made his way to the Catskill Mountains where he planned to end it all, which he did. The worst in human behavior, but he needed vindication. He needed validation. He did what so many people do in the United States, where they resolve conflict not by the appellate process, but through the access to firepower. With this tragic story, where we can conclude that the court of public opinion, well, at least in the form of that information, that personal information that is available online, like that personal information, that identifiable information that gave Hollander the ability to actually locate the home in New Brunswick, New Jersey, where Judge Salas and her son and her husband resided, where they can become the subject, the object, the target of retribution. They weren't the only ones. In fact, as Judge Salas, through her grief, began to employ herself, target herself with a new purpose, she began to attempt to identify all that is wrong with the court of public opinion, particularly as it applies not to the approval of the public insofar as allowing a particular justice to retain their official authority pursuant to that office as judge, but to improve the safety and security of the federal judiciary. It was Judge Salas who led the efforts. And because of her efforts, in her son's name, Daniel's Law was passed, the Judicial Security and Privacy Act of 2021. Judge Salas, her son was killed, her husband was wounded in an attack that was meant for her. A former litigant in her courtroom found her personal information on the internet and came to her home intending to kill her. It's because of the writing of Hollander that we can conclude that he was targeting her for race and gender, some of the same issues that polarized the court in Santa Clara County, concluding that there was a lenient sentence, and not through the appellate process, but through taking matters into our own hands, increasing the awareness of the general population, sharpening those tools at the disposal of the court of public opinion. Race, gender, other ways that we might determine a traditional interpretation of disenfranchisement, bias, what it is that the Constitution provides, what it is that we're willing to accept. When the FBI discovered an online publication of the Manifesto of Hollander, they found another name. In addition to 3 other federal court justices, all women, the name of Supreme Court Associate Justice Sonia Sotomayor was among them. It was Judge Esther Salas that we can thank for helping us to have a better understanding about the threats to federal judges. It's the FBI and the Department of Homeland Security, the United States Marshal's Office, that all report 400% increases over the past 5 years, identifying over 4,000 incidents. This includes hate mail, phone harassment, protests at homes, and attempted murder. It's Judge Esther Salas who went on the crusade to improve the safety and security of the federal judiciary in her son's name after suffering such a profound loss to her family, with her son being murdered by an individual who appeared at her front door, lying in wait, masking himself literally. United States Marshals who protect federal judges, they're asking for 1,000 more officers. They need more budget, and they've asked for $250 million. And it's because of, well, the help of the judiciary, specifically the Senate Judiciary Committee. Both sides of the aisle, they shook hands on a very rare occasion, so they might identify not only Roy Den Hollander, the lawyer who ended it all in the worst way possible, but also the dramatic rise in threats against federal judges in the United States. And it was this unified effort where the legislature, without the benefit of Judge Salas, who, because of the ethical constraints, could not advocate for particular legislation, but in this particular matter, she was the victim. She appeared as the victim, as she was, as we consider the impact on victims and how it is that we might protect those individuals within the legal profession who are tasked not necessarily with advocating for men's rights, but for all of our rights to promote the Constitution in the way identified through the Constitution, delivering the very integrity, the credibility of our justice system. It was Hollander who railed about discrimination against men, but it's also Hollander who was ethically challenged in the solutions that he applied to this appearance of impropriety. And as we consider the appearance of impropriety, we might consider that very same Senate Judiciary Committee, who recently, at least following the linking of a draft opinion to the media, one that is particularly politically charged, Dobbs versus Jackson Women's Health Organization in 2022, overturning a half century of legislation, litigation. As we can consider Roe versus Wade and Planned Parenthood versus Casey both being overturned by Dobbs, we didn't learn that upon the adjudication of Dobbs. In fact, we didn't hear that upon the publication of the opinion, Judge Alito's opinion. It was leaked. And when it was leaked prior to the adjudication, well, that created impetus. Perhaps it was a dog whistle as we consider those wolves among us and how we identify them. Because it was such a man who traveled from California, not unlike Hollander in 2022, immediately following the publication of the leaked document, without the benefit of the process and procedure, without the benefit of looking at the official declaration. They were suspicious of a system that was disenfranchising so many, at least in their perception. It was the California man who, armed with a suitcase and backpack filled with a tactical knife, a Glock pistol, 2 magazines, ammunition, pepper spray, zip ties, he was apprehended outside the home of Associate Justice Brett Kavanaugh. This rattled Washington. It raised questions about the safety, the security of the Supreme Court justices as they then were preparing to deliver an opinion that upset so much within the court of public opinion. Roe versus Wade, the autonomy over one's body, something that we have taken, well, perhaps for granted over the past half century, way back when we began to understand those challenges in regard to the appearance of impropriety. It was this individual who was apprehended who later told police that he was upset about the draft Supreme Court decision that would overturn precedent granting a federal constitution right to abortion. According to the criminal complaint, it was the motivation of this particular individual who was able to have privy to the opinion from the court, published through Politico. We can compare and contrast the impact of the court of public opinion. We might very well be able to understand the interest in the people's right to know, evidenced perhaps by the Life magazine article on the eve of the declaration by Associate Justice Abe Fortas a half century ago, or Politico that exclusively reported the leaked draft prior to its official publication. This contributes to the increase in threats, the rise in threats against the court, not necessarily exclusively in response to national abortion rights. There are many sources of agitation for the court of public opinion. The United States Department of Homeland Security issued a memo warning law enforcement that there was a potential threat to members of the Supreme Court. This was immediately following the leak of the Supreme Court opinion. So what's the worst that can happen? We can examine that memo and we can learn that the Supreme Court police, well, they noticed that there was a major uptick in social media threats on violence. So what do? Do we look to the Senate Judiciary Committee? Because it's that very Senate Judiciary Committee that has recently concluded that the actions of Justice Clarence Thomas, as he has accepted luxury travel, private jets, time on the yacht from the Texas developer, who also happens to have the largest private collection of Nazi memorabilia. This individual who has reportedly paid for the education of Clarence Thomas's nephew, has sold his mother's home to a developer without reporting the transaction. It was Clarence Thomas who is in receipt, not unlike Abe Fortas a half century ago, that is in receipt of so much, let's call it wealth. If we can consider the contributions of this particular donor and the impact on the court of public opinion, at least as it applies to the appearance of impropriety, it serves in that downward spiral. And we might consider how it is that we can check and balance through the constitutional mandate, that same Senate Judicial Committee that in unison concluded that justice is needed to be more secure and safe, particularly at home, that access to personal information should not be available. That in this particular case, when they asked Justice Thomas why it is that he did not disclose the lavish gifts, the financial security that would be afforded by so much wealth, maybe a Roman forum, the perception, unseemly. We might conclude that this is selective outrage, that maybe we only get angry when a liberal justice does something. Maybe that's what Senator Lindsey Graham was referencing when he said, what I would urge the court to do is take this moment to instill more public confidence in response to what he also concluded was ethical transgressions, not only by the living justices, but following the death of Justice Ruth Bader Ginsburg, the liberal icon who died in 2020. It was Leslie Graham. It was the senator from South Carolina who contends that the ethical breaches were ignored by the mainstream press. It's Senator Lindsey Graham who is responding to the court of public opinion, apathetic as they may be in response to what it is that Clarence Thomas reported, that he made no disclosure because the statute did not require it, giving impetus to many within the Senate Judiciary and Congress to conclude that we need to hold the Supreme Court as well as the federal judiciary to a higher standard. Considering the contributions of Stanford law professor Michelle Dauber following the Brock Turner case, maybe we should not only emphasize that victimization within the superior court system, but that this should be something that we should entertain from coast to coast, independent of the jurisdiction. Maybe consistent with the impulse of the senator from South Carolina. As I'd like to share a story from South Carolina, Hampton County, South Carolina. This is the story of Alec Murdaugh, 54 years old when he was convicted in the double murder of his wife, Margaret. Tragic. He was also convicted of the murder of their youngest son, Paul. This is in the June of 2021, where Alec Murda rhymes with murder, becomes the face of all that is wrong with the profession. In South Carolina, it's the Murda family that has been tied to South Carolina's justice system for over a century. Transgenerational power, holding the 14th Circuit Solicitor General position and controlling a powerful law firm established by his grandfather. Nepotism, access to wealth. The same firm that accused him of fraud and, well, through a cost benefit analysis, concluded that they would be far better without Alec Murda. His brother, Buster, who is still a part of the firm that bears the family name, they concluded that they would be best without Alec amongst their group of attorneys representing the interests of the good people of South Carolina. It was this firm that not only accused him of fraud in stealing the client money, commingling the assets, they prompted his resignation. This was the story that was then made available throughout the country. It's become viral in its nature, streamlined, streaming this particular scandal, a very Southern scandal. In fact, that's the name of the true crime documentary that is featured on Netflix. There are people from coast to coast who see the Southern scandal, the story of Alec Murda, the double murder of his wife and child, shotguns at their residence where the shotguns are kept, his wife and son, high immorality evidenced by so many lawyer jokes, a trait no less natural to the legal profession as the red hair on the head of Alec Murda, the disgraced former attorney, Murda, like murder. In the hierarchy of criminal behavior, life is valued above all. In the hierarchy of criminal behavior, life is valued above all. However, in the hierarchy of justice, it is the profession and the practitioner who are entrusted with the integrity of the judicial system. Trust, through transparency and accountability, the tools with which to check and balance our constitutional republic, so to dispense consistent with the demands of those rights and remedies, are protected and delivered by practitioners who have taken an oath to support and defend them. Oath, independence, and accountability. The way in which we might respond to countless contemporary examples of ethical challenges in the legal profession. A diagnosis with a preventive cure. A deontological approach where the righteous path preserves a just result. In the aftermath of the high-profile murder conviction of Alec Murda in South Carolina, where the face of Alec Murda becomes the face of all that is wrong with lawyering, the legal profession, although there never seems to be a shortage of high-profile examples of bad behavior, we have standards of professional responsibility crafted through time, tough times, under difficult circumstances to guide our decision-making so we may do the right thing. This is particularly true for the legal profession, as it remains incumbent upon all practitioners who conduct the impacts, who receive the rights and remedies and preserve the rights and remedies of those they serve, the judicial process and Constitution of the United States. It is the model rules of professional conduct and model code for judicial conduct. It is the legacy of canons of professional ethics, evolving since the 19th century and published by the American Bar Association. These reflect ideal approaches to virtually any potentially ethically challenged situation. Accountability, confidentiality, discretion, and presumptions of the abuse of power. Appearances of impropriety causes deterioration of the public trust. Stereotypes, perception, and the deterioration of trust. What's the worst that can happen? January 6th, perhaps. Integrity of the profession, credibility of the judicial process, and trust in the way justice is dispensed in the United States, transparency through application of codes of conduct intended to preserve the guarantees provided by our Constitution, oath, independence, and accountability. It's from the ethical traditions where we have received, perhaps by standing up on the shoulders of giants, those giants who have come before, those philosophers of ancient Greece, where we might remind ourselves that it is the legal profession that is of the sophistic tradition. It's the sophists who were concerned with virtues of moral character, traits that underlie or explain a disposition to act in the right way. We can conclude that the sophists were of the teleological tradition. Telos, meaning end. The end justifies the means. A theory of morality that derives duty or moral obligation from what is good or desirable as an end to be achieved. We might recall Che Guevara, who would remind us that we need to break a few eggs to make an omelet. There might be the law enforcement officer perceived to be abusing their power, who might conclude that the streets must be cleaned by cracking a few skulls. Means be damned. It's the end that justifies those means. But if we can consider the interpretation of the sophistic tradition from the sophists who made their information available, their knowledge available to the very wealthy, communicating that truth is what they can prove it to be, perhaps through a presentation of evidence, not unlike those individuals within the four corners of a courtroom who presume to be delivering the constitutional imperative by way of proving things to be true through the application of evidence, empiricism. Well, we can contrast this with the contributions of Socrates, Plato, Aristotle. Truth and the way through truth is not that the ends justify the means, but by understanding that the righteous path preserves a righteous result. Deontological ethics, theories that place special emphasis on the relationship between duty and the morality of human actions. The term deontology is derived from the Greek meaning duty, duty. As we consider the application of the way through reason, the way through reasoning what is right, the contributions of Aristotle as far back as 300 of the Common Era. We can jump forward in time, the evolution of thought, where truth, duty, and the categorical imperative of Immanuel Kant way back on the eve of the creation of our Constitution. Across the ocean, in Germany, we have Immanuel Kant, who in 1797 published Metaphysics of Morals, where the categorical imperative emphasized duty is a moral and legal obligation. It's from this categorical imperative where we might better appreciate the constitutional approach, where the Constitution of the United States requires that the legal profession, continue to exist. It's the very Constitution of the United States, through the First Amendment, that identifies the right to petition the government for a redress of grievances. That through the Sixth Amendment, we have the right to a fair trial and the assistance of counsel, where we have the right to due process of law, pursuant to the Fifth and 14th Amendments. It's the legal profession that requires the constitutional imperative, the way, the righteous path to preserve a righteous outcome. The courts are independent, impartial, and subject only to the constitution of the law. According to the great Justice, Chief Justice John Marshall, way back in 1803, Marbury versus Madison, it is emphatically the province and duty of the judicial department to say what the law is. In order for us to trust in the law, we need transparency and accountability. Should we tolerate an equivocation of truth, where righteousness might also be argued? Sophistic interpretations of reality, or worse, truth to the highest bidder. It's truth with the intrinsic value ultimately incalculable, yet subject to discretion of judicial creditors. The authority of the court declared, certified, codified, made precedent. It's been said that there are only 3 lawyer jokes, and I will not bother you with those jokes today because, after all, lawyers don't think they're funny. People don't know their jokes. From the sophistic tradition comes teleological approaches to ethics. Breaking eggs to make omelets, cracking skulls to clean up the streets, winning for the highest bidder by any means necessary is the objective. Capital punishment as a sustainable solution is teleological because the state kills, because killing is wrong. Perhaps it's an oxymoron. From this tradition, we have Socrates, Plato, we have sophists, deontological approaches to ethics. We have Immanuel Kant and the categorical imperative, but we also have the great Chief Justice John Marshall, who wrote, "A law repugnant to the Constitution is void." Like Kant's categorical imperative, ours is the constitutional imperative. Therefore, a prescription for our bad behavior in our justice system is to ourselves with commitments to duty and morality, consistent with everything our Constitution provides, a deontological approach, the constitutional imperative. Nervous practitioners, subject to the court of public opinion, they might conclude that, well, perception does matter, and that judges might very well, at least deontologically, not be on the appearance of impropriety. A justice system of which to be suspicious or feared if it isn't. Without the way, deontological, a righteous path to preserve the righteous result, it's no different than the shake of a magic 8-ball, or perhaps an algorithmic AI application guided by precedent, legislative intent, a trajectory of case law to best interpret what the Constitution demands. We have a tradition of sober judges looking backwards, applying time-tested solutions to those significant legal problems before the court. Dispensing justice makes whole those whose rights are most impaired, providing justice to those who need it most. Justice, or what tastes like it, is the raison d'etre of the institution or department that bears its name. Nowhere near worthy of trust. Perhaps the tough decisions under difficult circumstances must be addressed. And as we consider that former president that resigned from office, that Duke University School of Law educated attorney, perhaps we might conclude that a recent president has been indicted, impeached a number of times. This is where I will emphasize that this individual was not a lawyer. However, we have recently learned of a federal court judge named Cannon, appointed by that very judge, who is now scheduled to be before her in the District Court of Southern Florida. The question is, should this particular Judge Cannon recuse herself? We can examine those canons of ethics as we consider the dynamics of decision-making, not only by this particular Judge Cannon, but the other canons through select sections from the Model Code of Judicial Conduct. Model Code of Judicial Conduct, Canon 1. An independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved. Oath, independence, how it is that we might have accountability. I offer you the Model Code of Judicial Conduct, Canon 2. A judge should avoid impropriety and the appearance of impropriety in all activities. Respect for law. A judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Oath, independence, accountability. From the Model Code of Judicial Conduct, Canon 3, a judge should perform the duties of the office fairly, impartially, and diligently. The duties of judicial office take precedence over all other activities. The judge should perform those duties with respect for others and should not engage in behavior that is harassing, abusive, prejudiced, or biased. With what we've discussed today, perhaps for fear of running afoul of the court of public opinion. Respect for the law. A judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. We might contrast these rights, these models, these aspirational codes of conduct, where we might not necessarily emphasize the judiciary, but also the practitioner, those within the legal profession, through the ABA Model Rules of Professional Conduct, Rule 1.1, regarding competence and client-lawyer relationships. In determining whether a lawyer employs the requisite knowledge and skill in a particular matter, relevant factors include the relative complexity and specialized nature of the matter, the lawyer's general experience, the lawyer's training and experience in the field in question, the preparation and study the lawyer is able to give the matter, and whether it is feasible to refer the matter to or associate or consult with a lawyer of established competence in the field in question. In many instances, the required proficiency is that of a general practitioner. Expertise in a particular field of law may be required in some circumstances. As we consider what it is that the attorney believes that they can accomplish, providing their services to those who need it most. And in providing those services, we might also consider the Model Rules of Professional Conduct, Rule 1.6, confidentiality of information in the client-lawyer relationship. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation of the disclosure is permitted by paragraph B. Paragraph B, rather extensive, includes that the lawyer may reveal information relating to the representation of the client to the extent that the lawyer reasonably believes that it is necessary. And as we consider the oath, the independence and the strategy deployed by the particular professional in this matter, we can conclude that it's ultimately the rights of the individual who is seeking the assistance of that attorney. We might remind the attorney that consistent with the constitutional approach, that constitutional imperative, that there's a way. And as we consider the impact of the court of public opinion, we need to remind ourselves that the Model Rules of Professional Conduct, specifically Rule 3.6, involves trial publicity. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood materially prejudicing an adjudicative proceeding in the matter. Nevertheless, after the gavel falls, we might conclude that it's that court of public opinion that has been inspired to respond to those perceptions of injustice. If we can remind ourselves that anyone practicing the golden rule by way of the Judeo-Christian as well as karmic traditions from Vedic scripture, the notion treat others as yourself, at least in the state of California, we might conclude that parties to a particular matter, particularly victims and their families, whole communities represented, well, they are more likely to accept the authority of what is perceived to be credible. As emotions raw and on display at the penalty phases of criminal trials, victim impact statements, boxes of tissue at the ready, with the seemingly cold yet altruistically restorative gears winding toward justice, guided by the model rules of professional conduct, delivering zealous representation, promising not to mislead the court. We can conclude with the model rule 8.4 to maintain the integrity of the profession. The model rule defines moral turpitude to include offenses concerning matters of personal morality. A lawyer should be professionally answerable for offenses that indicate a lack of characteristics relevant to the practice of law. Offenses involving violence, dishonesty, breach of trust, or serious interference with the administration of justice. A pattern of repeated offenses, even ones of minor significance, should be considered. It can indicate indifference, particularly to the legal profession. Similar to most jurisdictions throughout the United States, it's sections 6106 and 668 of the California's Business and Professions Code that prohibits a lawyer from committing any act involving moral turpitude, dishonesty, or corruption. The Marta family in South Carolina, tied to the judicial process for generations. Money, lies, dignity of the profession, the face of all that is wrong. In our ongoing exploration of all things ethical, we should be mindful of all of the technological advancements that might very well bring about access to the judicial process, putting those involved in the process at high risk. Oh, what a tangled web we weave when we practice to deceive, Alec Marta told the court, concluding that he should testify on his own behalf prior to being found guilty through that hierarchy of criminal behavior on display, the murder of his wife and child. He defended himself by letting the court know that he had a problem. He was addicted to opioids. He had an addiction that clouded his judgment, his decision-making. And it's because of his addiction to opioids that he made the decisions that he did. We can use this as a cautionary tale as he concludes that he practiced to deceive, as we must practice through reason to do the right thing, to be moral. The constitutional imperative, oath, independence, accountability, avoid the appearance of impropriety. Integrity is everything. The constitutional imperative demands it. Duty, oath, independence, accountability. For the Center for Continuing Education, I'm Greg Woods.